evening, everybody, both
great.
here and out in the world. They're not watching the football, they're watching this tonight. It's my pleasure to welcome you all to UCL, to this IBIL event. It is my duty to tell you to turn off your phones, and it is again my great gratitude, and I have to say that I don't have to chair anything because I've got somebody much better who's written a book about the subject. David Stone is your chairman. David, you're on.
Hello everyone, and a very warm welcome both to those of you in the room and those of you watching live from somewhere else. My sense is that the less you hear from me at this point, the better. What we're going to do tonight is hear from each of our speakers for 8 minutes each, so they're fairly tight presentations. Each of them will deal with a particular subject matter, and then the aim is to throw it open to questions. Questions from me, questions from you, questions from those who are remote, with the idea being to try and tease out some of the ideas around this consultation that is currently going on, so that we end up with a better set of design laws in this country. So without further ado, if I can, Jeff, hand it over to you. And if you could just pop that in front of you while you speak, that would be very handy.
Absolutely. Thank you, David. Okay. Thank you and welcome everyone. So as the slide says, I'm Jeff Lloyd. I'm the Deputy Director for Trademarks and Designs Policy at the IPO. So I lead the teams looking at both trademarks and designs policy. So I'm just going to talk to you tonight about the designs review that we've been doing and that we are continuing to do. So to start with, where does the review begin? The review of designs law is an opportunity to consider what we can do with Brexit opportunities. It allows us to also seek broader views on issues that stakeholders have raised. Brexit has taken up quite a bit of time over the last few years, and so there is a bit of a list of things that have been raised on the design system. The design system also hasn't been reviewed since 2011, which I'm sure you're all aware. So, I think as the invite to this event said, it's been described by some as the Cinderella right. We haven't looked at it in some time, so it's definitely time to do that. So we began work on a call for views in September 2021, so just over a year or so ago. So in terms of the call for views, one of the things we recognised right at the beginning was that we don't just want to hear from kind of a usual suspects kind of audience of stakeholders. The design sector is very diverse. We have lone designers, we have SMEs, and we want to reach that audience. People who aren't necessarily as familiar with IP as professionals are, and as trade bodies might be. So we wanted to reach that audience as well. So in order to do that, we also decided to publish a survey alongside the call for views to reach those with less detailed knowledge of IP. So we launched the call for views in January this year, on the 25th of January, and it ran for 2 months until the 25th of March. As I mentioned just now, we also launched a survey at the same time. That ran for a slightly shorter window. It was a simplified version of the call for views that appealed to the audience with perhaps less detailed knowledge of IP. We also ran a number of bespoke stakeholder events, or took advantage of our regular stakeholder engagement. So we ran bespoke events with particularly trade bodies like ACID, including speaking to the ACID Council, and we also did bespoke events with our Marks and Designs Forum, which is a stakeholder body that we engage with regularly, which is trade bodies and legal professionals. These events involved senior people in the IPO up to and including the CEO, so this was very much an IPO priority to engage as broadly as we possibly could. And then in the course of the call for views, we received 57 responses, which we were very pleased with. That's a pretty good rate for quite a specialist call for views, we felt, so we got good engagement on it. And the survey also reached a wide audience. We got 288 responses to the survey, which again we were very pleased with. So what followed next was analysis of what came out of the call for views. So we started looking at what the key themes were that people had identified. A key thing, and not unexpected to us, is complexity. Could we do anything to simplify the system? We have multiple unregistered design rights, as I'm sure you all know. We have design rights have a complex relationship with copyright and an overlap with copyright, which is another level of complexity. So that was one key theme that came through loud and clear. The second key theme was about novelty searching and whether we should introduce that or some sort of two-tier system similar to the system they have in Australia. And also some people raised whether we could use AI search tools. So could we make better use of AI to establish the novelty of a design through a search? So that was another key theme. Again, something that we knew was an outstanding issue is deferment. Deferment is available in the UK design system, but it's not a formal deferment provision. So that was something that came through loud and clear from stakeholders that it was wanted. So another key thing there. In terms of enforcement issues, we had some divided opinion on, particularly around criminal sanctions, but there was concern around costs that came through to us as well, costs of enforcing designs and costs of litigation. We are also looking at designs opinions. So the 2014 IP Act does introduce provisions. It does give us the provision to introduce rules for design opinions, but we haven't activated that yet. So that's something else we are looking at. And then inevitably there were post-Brexit issues to consider as well, so particularly disclosure of unregistered designs. We didn't agree mutual recognition of disclosure of unregistered designs with the EU in the course of the exit negotiations and the FTA negotiations that followed.
1 minute, Jeff.
Sorry?
1 minute.
1 minute, okay. So it's an outstanding issue, so we are considering that, and one of the things that came through from the call for views is whether some sort of simultaneous disclosure could help. And then finally, new technologies, whether we should be accommodating different file formats and how flexible we can make the system to take account of new technologies as they emerge. So briefly, in terms of next steps, we published a response which set out some of these key themes on the 12th of July. That is available online. It includes the responses to the call for views and some analysis of the survey responses. So if I'm happy to share the link for that if anyone would like to look at it. So the key themes that I've talked about are now forming the basis of policy work on options and ongoing discussions with stakeholders. Unfortunately, work on retained EU law, which you may well have heard of, the retained EU law bill is before Parliament. That has slowed down work. It is taking up quite a bit of our bandwidth. Sorry, let's skip this forward. So that has slowed things down. Our timeline now is that we expect to consult now in the next 12 to 18 months on more detailed policy proposals. I'll leave it there.
Fantastic, Jeff. Thank you very much. Judith, you're next. Jeff, you will have noticed I haven't introduced our speakers tonight. Their details are all on the website. So, Judith, on to you.
Thank you. Hello everyone, my name's Judith. I am Operations Director at UK Fashion and Textile Association. I work on all our government relations across all different policy areas, but have been fortunate enough to have been a sector that was recognised by the IPO during the Design Rights Consultation that they held, and wanted to just tell you a bit more this evening about our thoughts around this. I guess really the context is to tell you about our industry. We account for 890,000 jobs and £34 billion to the economy in 2019. But we're dominated by SMEs, and not just SMEs, but micro SMEs. 80% of our companies employ less than 9 people. And many of our workforce are freelancers, which just makes that kind of intellectual property issue even more complex for us. 18% of our workforce are self-employed. We are a truly international industry. We're multi-component goods, a bit like cars, so everything you see in an item of clothing is extremely complex in terms of how it's made and the parts within it. So our production spans multiple borders, as does our sales. So if you're looking at high-end fashion, most of our designers, their first ever sale that they achieve in their business will typically be an order from abroad, not from the UK. It wouldn't be Harrods, it would be somewhere in New York or in another territory. So again, makes our IP extremely complex. We are an industry that has multiple product lines that we invent multiple times of the year, which is quite ludicrous really, and I doubt any other company would try and do that, but for some reason we do that often, every year. So we have seasonal ranges. Most clothing lines you'll have 2 sort of ranges, full ranges a year, and then with multiple drops during the year of additional product. At high-end fashion, you're probably looking at 6, 8, 10 ranges a year, but then if you look at high street, it'll be way more than that. You know, some high street retailers have multiple drops of new products every other week. Products, if you think about high-end fashion, are disclosed at fashion shows and presentations and sales meetings, and typically that will be 6 months before they actually go into store, which again creates a problem because you've disclosed a long time before you're actually selling. So you have to have that protection in place during this period. At the heart of our industry is creativity and design. So design rights are hugely important to us. And I think they'll become more important as we go into the future. Virtual clothing, skins, that market is estimated to be $40 billion a year. Another big area of concern for us is sustainability and thinking about longevity of garments, and I'll talk a bit more about that in a moment. So thinking about gaining rights, we need to be fleet of foot, we need to minimise costs, we want automatic protections. It's the only way, having described the industry, that this will work. We were opposed to search and opposition periods just because of the nature of the industry. And it's not just cost of registering designs, you know, that's prohibitive, but think about the cost of preparing all those images of multiple garments. The volume of work it creates makes it prohibitive. We usually only register designs for core products, but it's hard to tell what those will be before you've launched them. As I said, we're in multiple territories. Most businesses, the reality is they don't think about protection until they're infringed. Grace periods are very important, that 12-month window, and as I said, we really rely on automatic protections. Simplification and harmonisation is very important across IP rights, but also across different territories. Most designers, I hate to say it, do not understand the concept of disclosure at all. They'll quite often have a sales or press meeting the day before a show and not realise that if they've not put NDAs in place, then they have actually technically disclosed what they're showing. What we need is industry examples, using kind of language and examples that they can relate to help understand this. So, you know, harmonising systems, particularly to those internationally, making sure, you know, in a global industry that brands feel that the UK is a safe harbour is very important to us. So the complexity of the design system as it is really provides challenges. We rely heavily, surprise, surprise, no surprise here, on unregistered designs, and we've already just heard from Jeff that it was a cost-effective mechanism to get rights throughout the EU. At the moment, we don't know if UK disclosure will give you EU protection as well. So at the moment, most of our designers are left in limbo. This uncertainty is actually putting showcasing platforms such as London Fashion Week at risk. I don't think probably the majority of the industry realise that yet. Again, it will be when they're infringed that they'll realise the importance of that statement. So having things like simultaneous disclosure as an option is really important to us, but it's not tested. There isn't any legal, it's not protected in the legal system as yet. And I think it's probably unreasonable to expect that, waiting for a legal decision to give us an outcome on that will be so important for our sector is going to be extremely difficult, especially given the cost that one company will incur on getting that. Thinking about products of the future, we would like to see more ability to file designs in 3D, 4D. Textiles themselves aren't static, so moving images, but also thinking about our industry and things like virtual merchandising and how you showcase product, fashion shows, etc. is really important to us. Enforcing rights is very costly. One member quoted to me £850,000 to enforce their copyright. One particular famous case. Again, in an industry of small businesses, how's that going to work? Can we really impose criminal sanctions? We think it would be difficult to implement. You turn to trading standards, they're hugely under-resourced. So it's difficult for businesses really to know what, where they stand. And also we're sort of slightly worried that it could also stifle creativity if you're constantly wondering, are you infringing someone else? There's takedown schemes that are offered by companies such as Amazon and other informal approaches. I don't know if any of you have ever heard of Diet Prada, which is a kind of kiss and tell site on Instagram where they out people who've copied particularly young designers. So, what can we learn from these kind of examples in a more legislative approach? What should we strive for? Well, part of my job is actually to encourage government to think of all the policy levers that they have at their disposal. I've mentioned sustainability and the importance to the fashion industry. If design rights could be lengthened, then that would help encourage us in terms of lengthening product and product not going to landfill or not being reused, rented, etc. It's a big part of the sustainability conversation. But what we do need is a really international approach to intellectual property, a fit-for-purpose IP system with reciprocity and harmonisation, because we really want to, brands, both UK and internationally, to know that the UK is a great place to trade and a really important part of our industry. So not just unregistered designs, but issues such as exhaustion of rights, etc., are very, very important to us. So that probably, am I...
Bang on time. No, you've done very well indeed.
That's what I wanted to say.
So we've heard from government, we've heard from industry, we're now going to hear from the Academy. Uma, over to you.
Thank you very much, Ilana and IBIL, for inviting me to this. I am going to concentrate on the overlap between copyright and designs, but actually I'm really going to talk about copyright protection of designs. And looking at UK law as it was, as it is, and as it could be, I came up with 3 different approaches. The first one is we could turn the clock back and return to quite romantic notions, and actually quite fictional notions, of William Morris and John Ruskin in relation to the concept of works of artistic craftsmanship, and a bit on sculpture as well, which is where the problem lies when you're looking at copyright protection of designs, that is 3-dimensional designs. However, looking at it very closely, I do call it the nuclear option, i.e. returning to it. There have been calls in the past for what we called the industrial copyright for 25 years, and this was done via Section 52. So one thing that the government could do, perhaps, is reintroduce Section 52 again. And this, perhaps, would allow courts to comfortably relax and award copyright protection for what the industry obviously wants, automatic protection. And copyright law is a global international system. We could turn or reject all the EU laws on our categories problem, which we have, on FLOSS, which call for cumulative protection, Coffermel-Brompton, which called for a different way of approaching three-dimensional designs. And part of some recent cases, Response Clothing and Water Rower, did seem to take an ambivalent approach, but perhaps we can put them aside as aberrations. But we need to bring back Section 52 on this, and I just think one shouldn't go back in law. I also said at the end, and perhaps we could really help industry by legislatively codifying Henshaw. Now, this is a very interesting experiment to codify Henshaw, and it should be given to those who clamor for a return to industrial copyright. If it's not feasible, then there's option two. And option two is, I think, what's currently happening now. And I call it the flexible historical approach. The flexible approach is let's look at that horrible phrase, works of artistic craftsmanship. And we know the legislation on it. We know what happened to Section 22 of the Copyright Act 1911. We know what happened to Section 10 of the Copyright Act 1956, and we know what happened to Section 52 of the 1988 CDPA. 3 different ways to try and cope with not protecting designs, especially three-dimensional designs under copyright law. Slightly disastrous, I would say, and they didn't work. Now, if you go back to why that particular phrase was brought in, it was brought in because of compliance with the Berne Convention, and keeping it in would still be compliance with the Berne Convention. The works of artistic craftsmanship did not reflect Ruskin and Morris. I looked back, the 1910 House of Commons debate said the reason we're bringing it in is because of Berne compliance. Of course, the word in Berne was works of applied art, but that was the French term, and I think it's quite believable that the English legislature decided not to take the French term and came out with works of artistic craftsmanship. Secondly, the House of Commons debate was very clear. We're introducing it in order to increase protection of works of artistic craftsmanship. I think that is the approach that was taken both in Response and Water Rower, especially Response. Now, what Response did was taking the historical approach. It said, let's look at it as if there's no EU law. Let's look at all the decisions that talk about works of artistic craftsmanship. Let's look at the wonderful decisions in all, how many? I counted it, 7 judgments in Henshaw, and as well as the Court of Appeal and Supreme Court in Lucasfilm. And let's also look, because we're not quite sure here, at Australian and New Zealand case law as well, in order to cross-check what our position is, and wonderfully and flexibly came up with the idea that, well, yes, it will protect mass-manufactured industrial designs. There's nothing in our current law. However, let's now switch hats and look at EU law just in case we need to. And then they applied Coffermel and Brompton, etc., and came up with, well, it will be protectable. That is a remarkable way of looking at it, and I think Water Rower did it to the same extent, and we can just leave it as that. I mean, as I said at the top, no legislative change required. All it requires is a very flexible court. A brave court as well. And I admired these 2 courts, actually, because through that gymnastics, they managed to straddle 2 streams of jurisprudence, the current UK stream of jurisprudence, as well as the EU jurisprudence. And do we really want to subject our judges to this? I mean, the stress level of doing this is untenable, I think. And on top of that, there's option 3. Now, option 3 is still, you don't have to do anything, but all it requires is, my favorite, a proper functionality doctrine. And that does require an active court. The functionality doctrine is alluded to by the Supreme Court and to a certain extent by the Court of Appeal in Lucasfilm. It is inside...
So advance your slides.
Oh, sorry.
It
is inside the previous case law. If you go back, right back, I found it existing in Cramp versus Smithson, House of Lords, 1944. And it's there in the idea expression dichotomy, which is part of our law, which is part of the TRIPS agreement, so it's doubly part of our law. And that functionality doctrine is already part of the Brompton, Coffermel, Lavola, the whole of EU jurisprudence, which is part of retained EU law. And it doesn't take a lot to merely desist the cries of those who say we can't have copyright protection because it's too long. Well, actually, I'll come to my last point on the HMG's review of Section 52. It's too long and it's too anti-competitive. First, functionality doctrine is supposed to do that. It's supposed to take out everything that could be too anti-competitive. If you look at the test as it's right now in Football Data Co, it says that particular phrasing as to how you can ensure competition. Secondly, in relation to it's too long, I just want to point to the 2021 HMG's review of the post-Section 50, the Section 52 exclusion or the taking out. And they pointed to three terms. There is a slide in it, but I'll just say it, and it's there at the end. Three things they pointed out to. Firstly, they said, we have to extend the term of protection equally to everything, including artistic works, because it will combat market failure. So in other words, they are talking competition language already in that review. Secondly, they said we have to do it because it will create a simpler copyright system, which we do need. And thirdly, we need it for incentivization of creativity in British design industry. So by option 3, I merely wanted to point out we would be taking into account two strands of policy. One that has already been taken by Wateroo and Response, I think. And we have to reject that policy strand in Supreme Court in Lucasfilm because that was based on an old landscape, which doesn't exist anymore. And secondly, it'll take into account the views already set out by the government in that policy implementation. Then, next steps.
1 minute.
Next steps, 1 minute. So, what do we have to do next? I would suggest that the courts start looking at functionality. You cannot have a legislative definition of it. It's something that comes out from jurisprudence, and I believe that they can. The second thing that everyone will say, what about the demarcation between registered designs law and copyright law? But the functionality doctrine is the one thing that actually unites trademark law, and it's also in trademark law, design law and copyright law. In relation to a bigger problem, which is patent law. The third point was, what's my third point? Oh, and the third point is perhaps one tiny amendment, which I've put in red. Just take out the word means and just put includes. And I think that might solve a lot of problems. We open our categories. This is what it was supposed to be. This is how it is within the categories they are open. It might be a closed list, but within that list, there is a lot of flexibility. There's case law about the flexibility. Look at all the case law about, I can give it to you, maps, charts, circuit diagrams, what was said in SAS, I've forgotten, SAS, Nova Production and Narodzian about the flexibility within the categories itself as to whether something is here or there. Am I within it? And one last line is, I actually think we shouldn't go back to the past, partly because it's not good policy today. It just isn't. Iconic British designs, even if they are of mass manufactured consumer goods with some utilitarian purposes, just deserve to be protected if you just put them through an originality test with a functionality doctrine annexed.
Super. There is something to think about. When Judith spoke to us earlier, Judith is from an organisation that represents many small businesses. We can't say that of George, who comes from a very large business, a business that has been before the British courts to protect its designs. George, over to you.
Thank you very much. So I'm George Sellier. I'm head of IP enforcement, brands and licensing at Dyson. And as David says, I'm going to provide the large business perspective on the designs framework, and in particular, registered designs. I should say these views are my own. They're not necessarily those of Dyson, but they're obviously informed by my time at Dyson, but also my life before that when I was in private practice. I spent 12 years primarily acting for other big businesses, taking action against infringers in the UK and elsewhere. So why do businesses register and enforce designs? Typically, the objective is to protect market share. That's what they're trying to do. And there are a few key factors that serve that purpose well, I think. Registration and enforcement need to be quick, and they need to be inexpensive. And designs need to be given sufficient breadth to prevent parasitic behaviour. And I know that copying isn't a requirement for infringement of registered designs, but that's fundamentally what we're trying to prevent most of the time. Sometimes it's exact copies, and sometimes it's copies that are inspired, perhaps, by the designs. And I'm going to refer later to some leading cases, and most of these involved pretty pioneering designs that had enormous commercial success. And the whole point of the case, the reason that it was brought by the design owner, was to take action to stop the imitators from riding on their backs in order to take their own slice of the designer's commercial success. But I don't want to get distracted by those cases just yet. And my main point is that a fundamental purpose of designs is to protect market share. And in order to achieve that, as I say, registration and enforcement of designs needs to be quick. Because if not quick, then action is going to be too late to effectively protect the market share. And I'll give you a real life example of why speed matters. So this is the flyaway attachment for Dyson Supersonic. This one was launched in July last year. It's pretty clever. I don't want to get into the functionality bits too much, but it uses the co-under effect to attract and lift longer hairs whilst pushing stray shorter hairs through the tress and out of sight. And what that leaves you with is a really sleek finish after using this without the need to go and use straighteners. So the function and the design are pretty groundbreaking, and it's been very, very successful. So we went away and registered community designs pre-launch with publication deferred, and there's a flipped image of the design. And then we went and filed applications in other countries pretty soon after, taking priority from the European design. There were copies within weeks, initially in China, but then in all of our major markets around the world. The US design patent is still pending over a year after filing it, meaning that we can't meaningfully take action in the US. So then you go on to Amazon.com and it looks a bit like this. So anyone searching for the Dyson Supersonic flyaway attachment probably won't find anything of ours, but they'll find all of these copies. And in case you're thinking just file earlier, that isn't a solution. I'm not going to get into that now, but if you want to come back to us in the questions, I'm happy to talk about that. So registration and enforcement need to be inexpensive as well. Some of this is obvious, but if registration is too expensive, businesses won't go and get the registered protection. The way businesses, or larger businesses, operate generally is that they have a budget for IP protection. We choose what and where to go and file it. If something's very expensive in one country, we might choose to go and file in 2 or 3 other countries instead, as part of the balance that makes up the budget. And if enforcement is too expensive, again, businesses will look elsewhere. Because if you're operating on a global scale, you're very unlikely to go and take action in every country where there's a problem. You might go and do just 1 or 2 and try and get a settlement out of that, perhaps. And I think if you look at IPEC, that has shown that actually if you bring the costs down, there will be much, much more enforcement. It opens it up. Fortunately nowadays you can get it even cheaper than that. With online takedowns, you can do lots of enforcement at relatively low cost. So in the past 12 months, Dyson's enforced designs more than 20,000 times in online platforms. By contrast, we've had about 10 cases in courts around the world. And enforcement in online platforms works okay. It's pretty good, otherwise we wouldn't have done it 20,000 plus times. But the tendency is for platforms only to accept complaints regarding products that are near identical. And you might think that it makes sense for the platforms to err on the side of caution because removing listings means that they sell less, or perhaps because the assessment is easier. But I don't think it's as simple as that, actually. Online platforms nowadays will do takedown complaints on the basis of patent infringement. So they're okay with making complex assessments, much more complex than the overall impression. I'm inclined to think that they probably follow the precedent set by the courts. And in my view, in too many prominent design cases, the courts have tended to construe designs too narrowly. You knew it was going to come up, Robin. So here we go. These are the 5 design cases that the Court of Appeal has seen in the past 15 years. And in every single one of those 5, the designs are valid but not infringed. And that's despite Procter & Gamble's, Dyson's and Magmatic's designs, at least, being acknowledged by the courts as being strikingly novel, step-change designs, many of them in design museums, etc., etc. These designs departed significantly from the design corpus and should have had a broad scope of protection. The imitation parasitic products were much closer to the design than the design was to the design corpus, and yet there was still no infringement. And I accept that not every case is decided in this way. Designers tend to do much better at first instance. It's definitely not 5-0 there. But the high-profile cases that we've had have set the tone. They've given the impression that registered designs offer only a very narrow protection, and that design law won't stand in the way of copycat products, when it should.
1 minute, George.
I wonder whether perhaps these decisions were made because the English courts were bound to follow European case law. Perhaps it forced too narrow a scope on groundbreaking designs, or caused the informed user to pay too close attention to the small details. So now that we're at the crossroads, we've got an opportunity for us to create a strong design system which supports designers and not parasitism. So I'm going to end with this. This is one of the recitals of the Community Design Regulation, and this refers to the role of design protection in encouraging innovation and development of new products and investment in their production. And I think that's a really, really important role, but which could easily be undermined. And now we have a choice. So whilst consistency is good, if we're not going to be bound to follow Europe going forward, let's look to make a design system which supports designers and encourages innovation, and make it a no-brainer for companies to come and register and enforce their designs here.
George, thank you very much, and certainly a lot there to think about. Sally, last but not least, you'll need the silver stick and the clicker.
Great, thank you. So, yeah, as it says on the slide, I am a partner at Mishcon Ray, so I'm giving kind of a private practice kind of perspective, and I actually work with larger corporations, but also through the various bodies that I support, some very, very small organisations, sometimes just one person, who might have a very global reach. I've only got one slide today, and the slide is up there because actually the position in terms of the current framework is too complicated for me to explain very easily. Sorry, Jeff. So it's easy for me to put on this slide. There are post-Brexit, and I don't need to talk this through. I know I'm amongst kind of experts here, and we can chat about it over drinks later. You know, we've gone from the pre-Brexit position, which was already complex to some, to a position where we've got 7 different overlapping rights, 8 if you consider copyright, and yeah, it's challenging. I think the reality is, I think in relation to the consultation responses, of which I've read quite a few of them and even contributed to some of them, There are some benefits of having different overlapping rights, and people do, as Judith says, engage with these things sometimes post-infringement, and it gives people options. However, the reality is what we experience with clients, or I experience, and I should say this is my personal comments, not necessarily from Michigan, is that the complexity of the system is off-putting, and people are unlikely to engage and perceive it to be expensive, and perhaps will put their budget somewhere else. So just looking at the system, and again referring to this current system, and maybe some suggestions for the future, looking at registered rights first of all, the real benefit of the current system, as people have alluded to on this panel already, is the speed and cost, and the fact that you can get registrations through quickly. And it would be a real kind of shame to add to complexity in that area. Things like the metaverse, which Judith touched on, are growing, and takedowns are, again, growing, as we were just talking about with George. Many people are relying on them as a means of enforcement, and designs are a really attractive way of engaging in that. So the UKIPO, as you talked about, Jeff, has talked about tools such as AI, and definitely easier searching to allow designers to take, and businesses to take more informed decisions. That would be absolutely welcome. But really, I would question how satisfying a clear in search would be using those tools currently. Certainly the idea of introducing a design opinion service, as has been discussed, is definitely of interest. Also in the same vein, suggestions such as opposition periods, examination on novelty, are unattractive, being that they would slow down the process and increase the expense of obtaining protection. And the same would apply to a twin track system, sorry if I missed you talking about that, George, which has been adopted in some systems. It would be very hard for SMEs and difficult for entrepreneurs to navigate, and I do also wonder whether businesses like Dyson would equally maybe not favour the complexity there, but I would be interested to hear later on. But looking at unregistered rights, now obviously we touched upon there are many unregistered rights, and there are some obvious things that will lead to less complexity. Obviously one of them just is the passage of time. So the continuing unregistered design right that was created post-Brexit, obviously we're now 2 years in, that will shortly fall away, so that reduces one, and that will just happen. So nothing for the UKIPO to do there. However, there are some arguments, I would say, for one unregistered design right, perhaps based on the supplementary unregistered design, and also some arguments to extend the length of protection from 3 years to 5 years, looking at the considerations that Judith talked about in terms of sustainability and the speed of bringing things to market. There have been some kind of manufacturing and supply considerations to think about post-COVID as well. And also, of course, copyright should be considered too, but I really won't go into that. Eva explained the complexity of that extremely well. The other thing that I just wanted to touch on post-Brexit and looking at the designs framework, and in particular on unregistered designs, and something that has been mentioned, is simultaneous disclosure. So post-Brexit, various issues remain to be resolved. And one of those is exhaustion, which is not a subject matter to discuss today. Another is really the disclosure of unregistered designs and the impact of where first disclosure takes place. So the interpretation of provisions around this area is not set, and brands are really, the uncertainty that they're experiencing has only been increased. And it's very difficult to navigate for SMEs, also for larger businesses, until we have a clear interpretation on that issue. Without this clear interpretation, businesses perhaps have no option if they want to reach certainty but to register, and that's really not, it not only takes significant time to register, and of course there could be other tools which would help you with, say for example, selecting designs, but it's a complex process. Again, it's off-putting. We have worked with organisations such as the British Fashion Council and London Fashion Week, and the issue that Judith talked about is a very real one. We have an amazing platform here to introduce businesses to an international network, but people may choose to disclose their designs elsewhere for more certainty because of this issue. Finally, coming back to simplicity, really I would say that actually businesses that we support through our mentoring programs and our clients are really looking in a very international way, whether they're based here or they're based overseas. Alignment and cooperation with the EU and other territories remains crucial, and an obvious example and a really easy win is deferment and aligning with the EU. However, as I've touched upon, some of the other questions are really not so straightforward, require careful consideration and discussion, and it's really welcome that the UKIPO and their responses actually have said that they wish to engage with those things. I understand that's why you're here today. And we look forward to engaging with those discussions with you. Thank you.
Sally, thank you very much. I would leave your slide there because I actually think it's very helpful for people in the room to see where we're at. May I have the silver stick? I am sure that there are a number of people here who are very keen to ask some questions. Before we get onto that, I'm just going to set some ground rules for the questions, and then we're going to have a rapid fire round of questions to get the juices flowing. There are no ground rules other than please state your name and some sort of affiliation where you're from. It would also be very handy if you want to direct your question to anyone specifically. I will repeat the question so that we're picking it up on the microphones. And it may well be that there are some people up here who can't answer certain questions. So there will be some things that some of us can't say about some things, and I'd crave your indulgence on that. So the rapid fire round, what I'm going to do is ask each of you, bang, 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 to give an answer to the question. The answers are yes, no, or can't say. No other alternative. Here are the, and then I'll ask you to show your hands. So first question, UK design system, too complex?
Yes. Yes.
You have to wait, Uma.
I was so excited.
Yes.
Yes?
Yes.
Yes.
Hands up for yes, hands up for no. Okay, next question, novelty examination, yes or no, or can't say?
Can't say.
No.
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 Hands up no, hands up yes. Few in there, okay, interesting. Next, criminal sanctions for design infringement, yes, no, or can't say?
No.
Can't say.
No.
No.
Can't say.
In the room, yes or no? Yes, sorry, yes, hands up. No, hands up. I think the no's have that one. And finally, if we were to have only one unregistered right, should it be 3 years, 5 years, or 10 years? Or can't say?
5 years.
Can't say.
10 years.
Can't say.
5 plus 5.
Oh, interesting. And in the room, 3 years? 2 hands? 5 years? Quite a few hands. 10 years? Interesting. All right, so something somewhere in the middle. Hopefully that's got some ideas going in the room. Who wants to go first? The gentleman down the back.
Thank you. Di Davis.
We've got a mic somewhere.
I'll speak louder. Di Davis, sole practitioner, geek, lawyer. So this is a question primarily for Professor Usulis, who actually is not Professor Usulis. I was intrigued by your description of the first option relating to Copenhagen blocks, that it was a nuclear option to essentially carry on with the UK approach of saying design rights and copyright, don't mix them. And I was intrigued to know what the rest of the panel would think about what I don't necessarily describe as the nuclear option, but rather the British option, where we can carry on what we're doing at the moment. So for the case today, I think, I'd like to know what the panels think, that we would just ignore Copenhagen's loss and carry on with the UK approach, which is don't mix design rights and copyright.
All right, so the question for the other 4 of you is, should we adopt Uma's option 1 and ignore the Court of Justice? Anyone brave enough?
I mean, I will honestly say that I can't say, because it's just too complicated. I haven't got my head around it.
Haven't got your head around what that might look like?
Yeah.
And what would fall in and what would fall out? And Uma, why did you reject that as a nuclear option that was inappropriate?
I think actually George had a good point. I'm trying to defer it to him. I really don't think that our law was that. I have a feeling we've all been distracted by the 7 judgments in Henshaw, and I think the policy statement by the Supreme Court of Lucasfilm is old. and outdated and not true. So everyone tells me it's what the UK law is, but if you go through it, you find a lot of cases desperately seeking to get out of a jail that has been placed on it, and it doesn't reflect the industry today.
Can I ask a follow-on question? Have you discovered a non-gendered term for work of artistic craftsmanship?
We could adopt the French one, works of applied art.
Or work of artistic
Work
artisanship?
of artisanship.
Just a thought. Thank you for your question. Any next question? Lord Justice Arnold.
All right, so this follows on from the question that was just asked. So those of you who didn't get what Dave said, I'm Richard Arnold from the Court of Appeal. So, and my question goes to Jeff, because the question, when I get to it, will be about the scope of the review. The answer to the question why we can't implement the nuclear option comes in two parts. Part one is the trade and cooperation agreement between the UK and the EU, the intellectual property chapter of which reproduces all the provisions of the Designs Directive and the Term Directive which underpin the reasoning in Floss and Kofema. So if you want to reenact Section 52 of the 1988 Act, you have to renegotiate the Trade and Cooperation Agreement, and I can't see that happening anytime soon. But part two relates to what Uma Sutherson has said, which is the problems with the pre-existing domestic law of copyright, and in particular our absurd reluctance to let go of this 19th century concept called work of artistic craftsmanship. If we are going to do anything about simplifying our law, we have to simplify copyright law, because that's the source of a lot of the problems. And the simple way forward is to have an open list of copyright subject matter rather than a closed list. And in that way, you can get rid of so many of these problems. Because if you do that, then, as Uma has said, you can deal with the problems that we have with industrial copyright in other ways, such as functionality, and then you can forget about all the unregistered rights. You can simply have copyright and registered rights, and it's a whole lot simpler. But therefore the question is this: what is the scope of the review? Are you empowered to look at the Copyright Act?
So,
Sorry, I'll just repeat the question for the... are you empowered to look at the Copyright Act?
So, I mean, it's a designs review, but we do recognise the overlap between designs and copyright and the issues it presents. You know, I don't deal directly with copyright policy, but our copyright teams are involved in this review, and we are looking closely at the interface. I don't think that's about the straightest answer I can give at the moment, I'm afraid, but you know, it's probably not as broad a scope as you might want, but we are certainly looking at the overlap.
Can I just comment on
Yes, of course.
the one?
Everyone knows Professor Sir Robin Jacob.
I rather agree with Richard, but the problem still has to be sorted out. We don't want copyright for 70 years plus life of author.
Yes, we do.
Well, we do we? Well, that's a separate subject.
For literary works, or for works of artistic craftsmanship?
For applied works of applied art. To use the French term, the Berne term. If everybody thinks that's a good idea, you really need to consult industry very seriously if they've got to look at copyright for 70 years in industrial designs. 70, a life plus 70. I think that would be a disaster myself.
But in essence, that's what Floss says.
I know. Has it done any good?
Uma's nodding for those following the transcript. Alana, can I just ask, were there any questions that were sent in advance that I need to know about?
I have been informed of.
Okay, good. All right.
I'm James Cinderella, I'm a barrister at 8 New Square in Lincoln's Inn. We have quite a history in this country of substantive, deep thinking reports produced in advance of legislative proposals for reforming our IP landscape. Does this review give an opportunity for sufficient analytical input to change the landscape in the way that we need to? I suppose it is directed at Jeff.
We certainly hope so. One of the reasons I mentioned in the presentation that the review has slowed down, one of the reasons is because we don't want to scale back the ambition when other things are taking up bandwidth. We certainly hope it will take account of whatever analysis and whatever viewpoints it needs to. We want it to be comprehensive as possible. I mean, I think I would say at this point as well that slowing the design review down, as I've mentioned, does not change the level of ambition.
And can I?
Could the other panel members express a view on that question?
Could I comment on that?
Yes, of course.
Because, I work with government across a lot of different policy areas, and actually that you're exactly right that it can choke the ambition. And what we're seeing more and more, and sorry Jeff, I'm not necessarily speaking specifically about yours, but that lack of data that backs up the lack of response from industry, because sometimes they don't know how to engage in consultations. That has, there's been a couple of policy areas that, we've fallen foul of that lack of data or lack of analysis of understanding changes in behaviour that would be created, that then mean that the ambition is lost, I'm afraid to say. There's been some of my experience, and some of it around IP.
Jeff, can I ask a follow-on question, which is that there's been an EU review ongoing now for 8 and a bit years.
Yep.
It's due out towards the end of next year now.
Yep.
It's been delayed and delayed and delayed. Is it worth waiting for that?
We would like to take account of it if we can, and examine what the EU comes out, what the EU publishes. They're obviously a significant market. So we would like to if we can, but as you say, it has been delayed multiple times, and I'm not. We would have to think about whether we changed our timeline if it were delayed again.
Right, because it doesn't seem, at least all the noise I'm hearing is that it won't suggest root and branch change. No, it will be evolution, not revolution, and possibly even just tinkering around the edges.
Yeah, that's our understanding as well.
Whereas I hear James saying, shouldn't we be more ambitious? Is that what you're saying?
Yes, when I started practice, it made sense to read the bank's report. It made sense to read the substantive report on confidential information, even though it didn't result in a legislative move. And in lots of areas, it makes sense to read the Law Commission's report. And I just don't see how this process gives an opportunity for a publicly funded piece of work of that kind of depth of understanding. And that's because of the process, and it's not a criticism of the UKIPO, but I'm wondering whether an opportunity might be taken to say, actually, we do need to wait for the EU review and then do something more substantial, but in a timescale that still works for industry.
Robin.
Just a reminder, we have these reviews from time to time. There was the Johnson Review in Designs, which nobody has ever remembered. Am I the only person in the room who knows it exists? Kenneth Johnson, the head of my chambers. Whitford did copyright. The legislation came years later. And so it's quite worrying sometimes that we do these reviews, and that's it. Some government thinks the job's done. You won't do that, will
you? Others will correct me if I'm wrong, but am I right in thinking that IP hasn't really troubled the Law Commission, at least for a while? I can't.
It's filled with threats,
That's right.
making no practical difference whatever.
Dids, you had a question.
Yes, thank you very much indeed. And good evening, everybody.
Dids MacDonald from ACID, ladies and gentlemen.
Yes, and Vice Chair of the Alliance for Intellectual Property. This is a question for Sally and possibly Judith. You're great champions of designers and strong connections with the British Fashion Council. And what do you and your clients think about the frustrations that it's a criminal act to intentionally steal someone's two-dimensional designs, but they cannot bring criminal proceedings when the two-dimensional designs become a three-dimensional dress and the design is stolen? So in other words, do you think it's fair that there is no level playing field in IP rights within the creative industries? Why should a designer not have the same protection in law when their designs are stolen than a songwriter, a filmmaker, author, etc.?
Who wants to go first?
You start.
Do you want me to go first?
You go.
Look, I think there's also that for me, personally, I think there's a balance between kind of rewarding creativity and protecting it, but also dealing with the challenges of you know, the criminal. I obviously spoke out just then saying that I was against the introduction of criminal sanctions. And that's partly because actually the designers not only have to protect their designs for them to grow, and obviously when they're looking at investment and those type of things, but they also have to navigate the complexity of infringing others. And so there's a balance, and for me, the balance falls not giving them those rights. And you know, I'm open to discussion and looking into it. And I know it's an interesting discussion, but for the complexity of clearance and the challenges that might present, that's why I fall on the side that I do.
I sort of partially agree. I think probably, maybe sort of avoiding your question slightly, what does sort of concern me about sort of some of the conversation and rhetoric that we hear, you know, through Uma's presentation, for example, is if we're not creating a system that's really fit for purpose, not just in today's world, but in the future world as well. And when, you know, you had me in my presentation saying, you know, clothes are multi-dimensional. You know, the movement of a fabric is as important, do you know what I mean, as how it looks in a 2D. But then thinking about kind of virtual reality and the you know, the opportunity that's there for the industry. So I would sort of partially agree with Sally and also disagree with her at the same time, which is why this is also challenging, isn't it? So yeah, but I do think that sort of looking too historically on how designs have been protected might not create a sort of fit for purpose, you know, schemes, etc. to take forward, because our world is set to change hugely in the fashion industry, how sales will be created, sustainability, etc. You know, the next 10 years, the fashion and textiles industry will not look like it does today. And so we need the legislative, regulatory environment to kind of keep pace with that. And like you say, make sure there is a sort of an equal chance for everyone. That sort of answer your question.
Can I perhaps refocus us slightly on something George was talking about, which was this slide here. And again, I'm going to do a rapid fire, but not with each of you. You'll be pleased to hear, just with the audience in front of us. So George told us each of these was found to be valid but not infringed, and Samsung validity wasn't actually an issue before the relevant court. But can I ask for a show of hands, and many of you will know the cases, many of you will have been asked these questions before, starting with Procter & Gamble and Reckitt Benckiser. Really the question I'm asking you is, does the lower device create the same overall impression on the informed user as the upper device? So in reality, was there, in your view, infringement, regardless of what the court held? So let's start with Procter & Gamble. Infringed, hands up. Not infringed. Dyson and Vax.
Me too. Those pictures are not very fair pictures. Let's take them from the judge.
We accept that they're not very fair pictures. Sorry, yes, I will do. Going again. So Procter & Gamble infringed, 30 people. Not infringed, 15 people. Dyson and Vax infringed, 32 people. Not infringed, about the same, a few more, 20 people.
I can include one other person, my clerk, when I was a judge. She brought him in, she said, no, sir.
Was she an informed user?
Yes.
Apple, Samsung, infringed, 3, not infringed, everybody else. Magmatic and PMS, the Trunky case, infringed, 45 people, not infringed, 6.
On the original.
All right, with a caveat. Pulson and Garmin infringed, perhaps half. Not infringed. All right. Interesting. Who put their hand up for not infringed for all of them? Who put their hand up for not infringed for 4 of them? Who put their hand up for not infringed for 3 of them? Okay, that doesn't add up to the number of people who put their hand up for not infringed. Thank you for that. George, does that give you some idea of what others are thinking? And many of the people in this room are experts.
It does. Yeah. So lots of people perhaps share my views, and I know that not everybody does. I appreciate that. And it is pretty difficult to give that answer without knowing the design corpus first as well.
I mean, particularly the Samsung one, because Apple to the world said it was about copying the iPad, but the registered design was nothing like the iPad.
I was there, Rob. I remember it.
Actually, what's interesting, for those of you that have got the time, if you go and look back to the judgments, both first instance and the Court of Appeal for these, so the Samsung and Apple case and the Pulson and Garmin case, they've got a few examples of what was there as prior art, as the design corpus. Nobody bothered for the others because it was so far away, it didn't really matter.
For my part, I think one of the challenges for tribunals making these assessments is, particularly with our process here in the United Kingdom, we spend a lot of time looking at the objects, looking at the design corpus, and the risk is that the tribunal members become experts. So they move beyond being informed users. Perhaps they started as reasonably circumspect consumers, although not always, moved through being informed users to being sectoral experts, which the Court of Justice tells us is too detailed, because a sectoral expert is likely to notice every difference and therefore find everything to be valid but not infringed. Lord Justice Armand.
Okay, I can't resist any longer. As you well know, but some people in the room may not, I was the first instance judge in Magmatic and PMS, and I found it was an infringement. But I was overturned by the Court of Appeal and the Supreme Court. But it has to be recognised that the reason why they took a different view was not because of the overall impression on the informed user, but because of a very strange approach to the scope of protection conferred by the registered design, which was roundly criticised by none other than our chairman, David Stone, in an article where he gave multiple reasons as to why the Supreme Court got it completely wrong. But that then leads to a question, because that is something that could be fixed by the review. So is that something the review is going to look at?
That's an excellent question. So Jeff, really the question is, can we somehow get some agreement on what dotted lines mean, what blank surfaces mean, whether a blank surface is a claim to an absence of surface decoration, whatever that means? Is this something the review could look at?
I mean, we aren't ruling anything out if things are brought forward. We want to.
How would we bring that forward?
We want to. Well, we will be consulting in due course. We are engaging over the course of the next few months and the next year or so. So I think we are happy to consider any issues that are brought to us. We are not, as I've said earlier, we're not scaling back the ambition or the scope of the review in any way. We want this review to deliver very real and very substantial changes to the design system wherever they are needed.
There we are. So that sounded like an invitation for someone who wants to write about dotted lines and claims to an absence of something to have a go. Hello.
I'm Marion Howard, Head of Membership at Anti-Copying and Design. We've come as a team. David, you have over 20 years' experience of many David and Goliath situations where sort of low, micro and SMEs have their designs infringed by big organisations.
I'll repeat the question, but yes, if you could speak up.
But yes, and obviously you're a very well-respected solicitor and now a very well-respected judge judging these cases. What changes would you recommend to level up the playing field for designers to bring actions against big organisations in circumstances where there has been a flagrant infringement of their designs?
These are my own views and obviously not the views of anybody else. A number of the speakers tonight have spoken about... Sorry, the question was what would I recommend to help small designers enforce their designs? Is that a fair summation of the question? A number of the speakers tonight have spoken about the cost of court enforcement. A reminder, of course, that there is the small claims track in IPEC for claims up to £10,000. And that seems to work extremely well. There are very few appeals from that track. And that is something that a lot of designers do themselves, so unrepresented. It is a procedure set up without costs awards in order to be very available to people. And I would absolutely encourage you all to recommend it to clients who otherwise would have difficulties elsewhere. The IPEC, of course, is another place to go, next step up. And I think, by and large, the IPEC procedure works extremely well to balance the playing field between small and large. And the IPEC has kept in it a number of cases where a large entity has said, no, let's drag this to the High Court. IPEC said, no, one of the parties is an SME, we're going to keep it here. So I think again, that's an opportunity. I think most practitioners are challenged to do an IPEC case for £50,000. I think that is difficult. But it does mean for a practitioner, for a designer, that if they lose, that's the maximum roll of the dice in terms of paying the other side's costs. It has actually just shifted up slightly, but it's still not the end of the world. I've not seen a design case go through the small claims track, but someone here can correct me if I'm wrong. And then, of course, there's the full High Court, where you don't want to be if you're a small or medium-sized enterprise. So I think the structures are there. I think a bit more of what Sir Robin once said. A registered design case should be able to be determined in half a day. I don't think it's ever been done, but it is something to aim for, because if it's done in half a day, then the costs are going to be significantly less. Less from practitioners saying, can we have expert evidence about all this? Because I'm not sure expert evidence is ever particularly helpful for these sorts of...
I think it's the unregistered designs that are the difficulty, and I think that from our members, trying to litigate yourself is nigh on impossible. Also because the law is so complicated that they can't navigate their way through to represent themselves in any meaningful way.
And maybe the answer to that, and it's not a matter for me, but a single unregistered design right that includes surface decoration and lasts for 5 years.
But also maybe we need to look at the damages framework and costs to make it easier for people to represent themselves and actually get back what they've lost.
Well, and it may be that larger additional damages awards to make up for some of that might be part of the thinking.
Just following on that, compulsory mediation?
Again, not a question for me, and various people, including the Master of the Rolls, have had a lot to say about it. Whether people forced into a room to talk to each other are likely to reach an agreement when neither of them wants to be there is a psychological question I can't answer. Down the front.
Hi, I'm Noah.
Hi, Noah.
Hi, I'm from UCL, and I want to first thank you all for being here and talking to us because it's been really interesting. I was wondering, we touched onto the aspect of being ambitious about the changes in design law that we want to make, and we also touched on about 4D and virtual merchandising, which might be the future of design, and I was wondering how we perhaps can, how do you think we can consolidate that in the changes we want to make to design law, and at what point it might lead to not being ambition anymore, but maybe becoming too ambitious.
So to summarise your question, in terms of the virtual world, what more should we be trying to do? Who would like to tackle that one? Are there virtual Dyson vacuum cleaners in the metaverse? Do people even need to clean in the metaverse? They may need to straighten their hair.
So things do exist, and we do not sell virtual products, but I can imagine that it is likely to happen in the future. I suspect that there are some that are already there. I've almost been deliberately blind to it because it's such a potential big problem, and I don't, for the moment, know how to resolve it.
Are you nervous at all that your current registered rights would be insufficient?
Yes, because it's not tested.
All right. Judith?
Look at me. I think it's,
There are certainly clothes in the metaverse.
There certainly are. There really are, and there are a lot of startup companies like Dressed and whatever that are bringing, design online and what have you, into the metaverse. When I said our industry will change in the next 10 years, it will hugely change in the next 10 years. Driven by technology, driven by people being more conscious of the fact that we all, we should be, wearing a dress once and putting it in the bin and what have you. So all these different ways of kind of, what you're selling and how you're doing business. It's just going to grow and grow and grow in the metaverse. You're going to have billions and billions and trillions of designs. So it's going to become hugely important. So you have to be ambitious, I guess. We might shoot ourselves in the foot, but I think, it's such a big part of the future of our industry, and it's going to be so important.
You said there was already 40 billion, I didn't catch whether it was pounds or dollars, probably doesn't matter at the moment, in virtual clothing. Is that your members that are selling it, or others?
Yeah, no, all sorts of different companies, and what you'll find is, if you're playing Fortnite or whatever, then you want the designer thing that you're wearing. So, the big brands are doing this, but also small ones. It's, because just as a small design is desirable when it comes off the catwalk because it's quite unusual, so it's an opportunity across the board. In fact, almost small businesses, it's almost more accessible for them, isn't it, to sell that way. It's a bit like, bedroom brands, as we call them, that start up and sell just through Instagram or TikTok or what have you. So, the way the industry is working, the way sales are working, the business models, it's completely changing. Sorry, George.
I know, but do the English courts have jurisdiction?
Wow.
Or for the bits of it targeted here, they do.
I think we need to be ready for it.
Questions, sir?
Hello, I'm Dr. Luke Bacon of the CEO, and thank the panel for an incredibly stimulating event. I just wanted to ask a question to George. You mentioned the need for IP in this area to protect market share. Unfortunately for Dyson, there isn't an intellectual property right in market share. So isn't there a danger here, and obviously others would welcome to comment that, if you tighten the infringement decision making here, and maybe all 5 or 3 or 4 out of 5 of these infringement decisions, that you may end up in a situation that we have seen in trademark law, for example, of the larger companies sending a lot of letters before action to smaller companies, where there's, in most cases, not much or if any confusion between different names, different logos, and so on. And of course, I mean, isn't the success of Dyson, multi-billion-dollar company, British success story, even with the law as it is, a sign that, maybe the law doesn't actually need to change. Maybe the status quo is enough, given that design rights are not the only IP right within the arsenal of Dyson.
So is your question, George, are you a design bully?
No. So we do think that businesses need to behave responsibly, and you're right. When we see examples of cease and desist letters being sent to people who are not necessarily infringing trademarks, frankly, I find that embarrassing as an in-house lawyer, and I don't think that people should be doing it. We shouldn't be design bullies. But putting my big business hat on, actually, I don't think that happens that much. We tend to prioritise a lot those cases that we take. So writing a cease and desist letter might not cost very much money, but it does cost some resource, and there is some money there. Generally speaking, big businesses don't go out to pick on small people who have accidentally infringed. That's not generally our aim. It is to stop those that are trying to take the market share away from us.
Well, come on, they're the Macs of this world. I mean, it doesn't happen to design so much. They don't Mac on anything, McDonald's sue, or Sky on anything, Sky sue, and so on.
David, I'll give you a right of response in a moment. So your point, Robin, is it does happen in trademark world, but it doesn't yet happen in designs?
No, why not?
Perhaps it happens more in trademarks. I'm definitely stepping away from speaking on behalf of Dyson. Definitely speaking away from speaking on behalf of Dyson. But perhaps it happens more in trademarks for those trademark owners that who realise there are vulnerabilities in respect to their trademarks. They need to be seen to be going out and trying to enforce to create the space around them, because the marks perhaps aren't strong enough on their own.
Yeah, I think for some people it's marketing as well.
All right. I think one of the challenges with cease and desist letters is the protocols require us to put so much information in there that they end up being long and sounding pretty aggressive, even if you try not to. Question?
Belinda Isaac from Mr. Solicitor. I have a question for George. Sorry to pick on you, George. But you were talking about protecting market share, and as the previous questioner highlighted, this isn't really likely right, but it is a business concern. And so if we're keen to encourage innovation, design create, we ought really as a society to protect that and ensure that you can participate on a fair playing field. So my question for you is, the problems that you illustrated were largely what I think you described as parasitic competition or slavish imitation. And so I wonder what your experience is in other jurisdictions where there are unfair competition laws or parasitic competition laws, and whether they suffice to address the concerns you have, and whether that would be a better model than trying to craft a design statute that doesn't really deal with the fluidity of the market and the rapidly evolving design rules.
So question, George, do we need a tort of unfair competition?
I quite like it. Yeah. So we're going back in time a little bit, and even before I can remember really, but before the time of the Dyson Vax case in the UK, there was a very similar case in France on the basis of parasitism and unfair competition, and Dyson won. So yes, it would be nice.
Uma.
I just want to add to that, to Belinda's question, which is an excellent question, and to piggyback on that, which is the arsenal of weapons. I find it quite odd as well to talk about design in a very siloed way, because surely you go with the entire package of laws. And one of the importance of the unregistered design right was to plug a lacuna in unfair competition law after, I think there was one judge in Roe who said there's no such thing as the tort of copying. But there are these unregistered design rights, and I find it very difficult, Jeff, and I don't know how you all are doing it, to discuss a reform in relation to a subject matter where you actually do have to look not just at copyright unregistered design right, and completely right, they have unfair competition in Europe, and also looking at how trademark law comes in as
3D
well.
trademarks.
Yeah. And going back to James's question, and I think we need a review of the entire area of IP law vis-a-vis design rather than, am I making sense, design law?
So a review of how do we protect the appearance of a product or part of a product, as opposed to looking specifically at, because we have the 7 design rights plus copyright plus passing off plus 3D trademarks, and it all sits together. What I'm going to do is take one final question from the floor, and then I'm going to give you each a chance, a 30-second chance to say something you feel you haven't had a chance to say. You can also pass, but I prefer not all 5 of you to do so. That would be a downward way to end the discussion in 2 minutes' time. So who would like to be our very last question? Down the back.
Thank you. I wonder if you could reverse the burden of proof for unregistered protection, because I think for the small designers, they know the work that they've put in to create that new design, and often the parasitism takes place because people jump on the trend, and that new designer has created that trend, and yet the burden of proof is on them to prove that they have the unregistered rights.
So reverse the burden of proof on copying or on subsistence? Subsistence. It's an interesting point. Any reflections on that? Make it easier to say this is mine, prove otherwise? I'm not entirely sure that's usually the problem, but maybe I'm wrong. Others might have ideas. For discussion over drinks, can we start down this end, Sally? 30 seconds for something you wish you'd said tonight, but haven't yet had that chance.
I think I've said almost everything, but I think for me, I think there's a lot of complexity around the metaverse we've talked about, and I think it's a real opportunity for designs, particularly because I think the approach taken in relation to trademarks does need to be looked at as well.
Jeff?
Yeah, I mean, I think I have covered most things, but just to reiterate, please do, if you are interested and able to engage with this review, then please do take the opportunity to do it whenever they are presented, whenever they present themselves. And I will just touch on the metaverse point. We're not blind to it. I mean, it is certainly part of the futures strand of this review, but equally we have a futures team within the office who are looking at the metaverse and the wider implications for IP, including trademarks. So. And
Jeff, do you welcome emails now from people who want to raise these issues, or will there be a process where that will happen?
I mean, I'm happy to have emails now. There will be a formal consultation in due course, but I don't mind people reaching out.
And do we have a rough idea when the formal consultation might be?
We're looking at 12 to 18 months.
So beginning of 2024?
Late 23, early 24, yeah.
All right, thank you very much. Uma, 30 seconds.
I just want to emphasize the fact that the categories in the copyright law should be opened up, should be viewed as opened up. And just to mention that the Whitford Committee 1977, yes, I read it last night, it's that the categories...
Were you having difficulties falling asleep?
The categories are not about creative or aesthetic qualities. Art, literature and music, the basic philosophy of English copyright law is economic.
Judith?
I think I'd probably come back to some of the points that were made earlier around, you know, evidence and the impact of changing things that it has. You know, anything that the government does change behaviour, you know, whether it's consumers or businesses. So I'd sort of like to just sort of reiterate that point and sort of make that plea to Jeff to understand that in terms of, you know, when you're implementing what you've decided to do. And come back to that point of government maybe working a bit more holistically around some of its agendas and policies, because actually a lot of them are kind of inextricably linked if you were to look at other areas of IP, but like exhaustion of rights and the impact that has on trade. Do you see what I mean? It's never just a kind of single silo issue. So I'd love to sort of see more discussion around that and bringing in some of the, you know, the evidence around the economic evidence, etc. I appreciate that's never easy. It makes it more complicated. But,
George?
So I won't go to 30 seconds, but yeah, let us just please protect those strikingly novel designs and give them the protection that they deserve.
So you're looking for something like a famous or well-known design designation, like famous trademarks.
I haven't thought of that, but yeah.
Design with reputation. Everybody, thank you so much. To those of you watching from elsewhere, to those of you in the room, thank you very much for a very enjoyable and entertaining conversation. Would you join me, please, in thanking our panellists?